So my partner Jacob Wander and I, Isabel Cruz, decided to research the topic of equality in America. Throughout our slides, you will find information from the Civil Rights Act of 1964, Reed versus Reed, Craig versus Boren, the Equal Rights Amendment, Lawrence versus Texas, and Hollingsworth versus Perry. Equality. It is a noun. It is the state of being equal, especially in status, rights, and opportunities. Here we have a famous quote by Martin Luther King Jr. It states, "We must learn to live together as brothers, or we will perish together as fools." Okay, so now we have the Civil Rights Act of 1964. Congress passed the Civil Rights Act of 1964, which prohibited discrimination on the basis of race, religion, sex, and national origin. Provisions of the Civil Rights Act forbids discrimination on the basis of sex, race, promoting, and firing in a workplace. The Civil Rights Act became effective on July 2nd of 1964. Now we have Reed versus Reed, a landmark decision of the U.S. Supreme Court ruling that the administrators of estates cannot be named in a way that discriminates between sexes. This landmark was decided on 1971. The case began when her teenage son, Skip, died tragically. According to Sally Reed, her husband, or ex-husband, Cecil Reed, was an abusive husband and father who deserted the family when their son was only 3 to 4 years old. So this landmark decision that took place in 1971, so the United States Supreme Court invalidated an Idaho law that required the selection of a man over a woman to serve as administrator of an estate when both were equally qualified. Now we have Craig versus Boren, a landmark decision that took place in 1976 of the U.S. Supreme Court ruling that statutory or administrative sex classifications were subject to intermediate scrutiny under the 14th Amendment's Equal Protection Clause. And the 14th Amendment states, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Now we will be talking about the Equal Rights Amendments, a proposed amendment to the United States Constitution designed to guarantee equal liberal rights for all American citizens regardless of sex. It seeks to end the legal distinctions between men and women in matters of divorce, property, employment, and other matters. The Equal Rights Amendment was first drafted in 1923 by 2 leaders of the women's suffrage movement. The first woman was Alice Paul, and the second was Crystal Eastman. For women's rights advocates, the ERA was the next logical step following the successful campaign to win access to the ballot through the adoption of the 19th Amendment. They believed that enshrining the principle of gender equality in our founding character would help overcome many of the obstacles that kept women as second-class citizens. Beginning in 1923, landmarkers introduced the ERA in every session of Congress, but it made little progress until the 1970s. It didn't help that for the most part of the 20th century, Congress was comprised almost entirely of men. In the nearly 5-decade span between 1922 and 1970, only 10 women served in the Senate, with no more than 2 serving at the same time. And finally, in 1982, following the expiration of the extended deadline, most activists and landmarkers finally accepted the ERA's defeat. But in the 4 decades since Congress first proposed the ERA, courts and legislators have realized much of what the amendment was designed to accomplish. A significant portion of the credit goes to Ruth Bader Ginsburg, who is the founding director of the ACLU Women's Rights Project, found success in arguing for the jurisprudence of gender equality under the 14th Amendment's Equal Protection Clause. Okay, so now I will be going over Lawrence versus Texas. The case of Lawrence versus Texas started in September of 1998 when two men, Tyrone Gardner and John Lawrence, right here on to the right, were arrested in Houston, Texas. The men were arrested because law enforcement agents found that they were engaging in consensual sex with each other. Sex between two men in the state of Texas was considered illegal under the homosexual conduct law. This case began on March 26, 2003. During the trial, these two men challenged the Texas law, claiming it was a direct violation of their 14th Amendment rights. So, Texas law enforcement agents arrived at John Lawrence's home after a neighbor issued a complaint that a person inside Lawrence's home had a weapon. When the law enforcement arrived at the Lawrence home, they found that two men were engaging in sexual activity. The men were immediately arrested because of their relationship. John Lawrence appealed, citing that his personal time and his relationship choices did not warrant an arrest. Mr. Lawrence was enraged. He did not think he was engaging in illegal activity by having a romantic relationship with another man. Mr. Lawrence also believed that the law enforcement agents unfairly broke into his home. The men thought the police had violated his constitutional rights by partaking in an unlawful search and seizure. The homosexual conduct law was the genesis of the Lawrence versus Texas case. The state law said it was illegal for a couple of the same sex to partake in any sexual activity. The case of Lawrence versus Texas began on March 26 of 2003. During the trial of Lawrence versus Texas, the two men challenged the Texas law by claiming it was a direct violation of their 14th Amendment rights. The Lawrence versus Texas case was decided on June 26 of 2003 and was heard in the Supreme Court of the United States. In Lawrence versus Texas, the United States Supreme Court ruled that the homosexual conduct law was indeed a violation of the 14th Amendment because it did not preach equality. In the United States, if a state passes a law, it must be placed on individuals in an equal manner. It must be enforced on all people, equality regardless of their race, creed, gender, ethnicity, and sexual orientation. The 14th Amendment to the United States Constitution does not allow the government from interfering on the rights of an individual to chase life, liberty, and the pursuit of happiness. The amendment is applied to all people regardless of their race, religion, age, and gender. Now I will be talking about Hollingsworth versus Perry. This was a legal case decided by the U.S. Supreme Court on June 26, 2013. That had the practical effect of letting stand a federal district court's ruling that California's Proposition 8, which had amended the state's constitution to define marriage as a legal union between a man and a woman, was unconstitutional. After Proposition 8 was adopted in 2008, it was challenged in U.S. District Court by two same-sex couples who wished to marry. Because state officials refused to defend the law, the district court permitted its officials' proponents, a group of private citizens, to do so. The court found the law unconstitutional and ordered state officials to cease enforcing it. Proponents of the law appealed to the Ninth Circuit Court of Appeals, which issued a stay of the district court's order pending its decision. The Ninth Circuit, in turn, asked the California Supreme Court to determine whether proponents of a state ballot measure may appeal a judgment invalidating an initiative when the public officials charged with that duty refused to do so. After the California Supreme Court replied that the proponents were authorized to assert the state's interest in the initiatives, the Ninth Circuit concluded that they had legal standing under Article 3 of the U.S. Constitution, and it affirmed the district's court holding the Proposition 8 was unconstitutional. The Supreme Court then granted a petition for it in December of 2012, but asked the parties to separately address the question of whether the proponents had standing to appeal. In its ruling, the Supreme Court held that the proponents did not have standing to appeal because they had not suffered a personal and tangible harm that a favorable judicial decision would likely to redress. The court thus backdated and remained the Ninth Circuit's decision with instructions that the case would be dismissed. The court did not address the issue of the constitutionality of the Proposition 8. 2 days later, the Ninth Circuit lifted its stay of the district's court order, and California resumed issuing marriage licenses to same-sex couples, including to the original plaintiffs in the case who were married that day. In a last-ditch maneuver, the proponents of Proposition 8 asked the Supreme Court to vacate the Ninth Circuit's lifting of the stay on technical grounds in order to allow time to prepare a petition for a rehearing. Thank you for watching.